Stephen Miller, the architect of President Trump's most draconian immigration policies, has struck again. In a recent press gaggle documented by BBC, AP, and PBS, Miller sent shockwaves through the legal community. He suggested the administration was seriously considering suspending habeas corpus for undocumented immigrants. Miller, known for his hardline stance on immigration, justified this radical proposal by claiming the United States is facing an invasion at its southern border. This rhetoric, while alarming, is sadly unsurprising coming from an administration that has consistently demonized immigrants and sought to circumvent the rule of law. Miller's argument hinges on a dangerously distorted interpretation of Article 1, Section 9 of the Constitution. This section does grant Congress the power to suspend habeas corpus in times of rebellion or invasion. However, Miller seems to have conveniently overlooked a crucial detail. This power rests with Congress, not the President. Furthermore, the current situation at the border, while challenging, in no way constitutes an invasion as understood by the framers of the Constitution. Miller's dangerous rhetoric is not just an academic exercise, it has real-world consequences. By invoking the spectre of habeas corpus suspension, Miller is sending a chilling message to the judiciary rule in our favor or face irrelevancy. This attempt to intimidate judges is consistent with the Trump administration's broader pattern of attacking the legitimacy of any institution that dares to challenge its authority. To understand the gravity of Miller's proposal, one must appreciate the significance of habeas corpus. Often referred to as the Great Writ, habeas corpus is a fundamental safeguard against arbitrary detention. It ensures that anyone detained by the government has the right to appear before a judge and challenge the legality of their detention. This right is enshrined in the Constitution and has been a cornerstone of Anglo-American law for centuries. Throughout American history, there have been very limited instances where habeas corpus was suspended. During the Civil War, President Lincoln suspended habeas corpus, but crucially, he sought and received congressional approval. Other suspensions occurred during the Reconstruction era in the South, in the Philippines during the Moro Rebellion, and in Hawaii following the attack on Pearl Harbor. Each of these instances involved extraordinary circumstances that posed a direct threat to national security. The current situation at the border, while requiring attention and resources, pales in comparison to these historical examples. The Trump administration's own Department of Homeland Security has repeatedly touted the most secure border in American history under President Trump. This begs the question, if the border is indeed secure, why the need for such a drastic measure as suspending habeas corpus? The legal community has responded to Miller's statements with a mixture of disbelief and condemnation. Legal scholars and practitioners from across the political spectrum have denounced Miller's interpretation of the Constitution as baseless and dangerous. Experts from Truthout, a progressive news organization, called Miller's legal reasoning a complete fabrication and a dangerous distortion of the Constitution. They went on to argue that Miller's statements were a clear attempt to create a pretext for mass human rights abuses. Reason.com, a libertarian magazine, was equally critical, characterizing Miller's proposal as legal garbage. They pointed out that the Supreme Court has consistently affirmed that only Congress, not the President, has the power to suspend habeas corpus. Jonathan Shapiro, a legal expert quoted by Reason, stated that Miller's interpretation was factually and legally nuts, adding that it's frightening that someone with his views is in a position of power. The near-universal condemnation of Miller's statements from legal experts highlights the dangerous and unprecedented nature of his proposal. It is a testament to the erosion of democratic norms under the Trump administration that such an outlandish idea could even be uttered by a high-ranking government official. Miller's attempt to justify suspending habeas corpus is not an isolated incident. It is part of a disturbing pattern of behavior by the Trump administration, a pattern characterized by a disdain for the rule of law and a willingness to exploit any crisis for political gain. This pattern is exemplified by the recent cancellation of briefings by Kash Patel, a former Trump administration official who had been scheduled to testify before Congress about his role in the January 6th insurrection. Patel, a close ally of former President Trump, is believed to have been involved in efforts to overturn the results of the 2020 election. His decision to cancel his scheduled briefings at the behest of Trump is a blatant attempt to obstruct justice and prevent Congress from getting to the bottom of the January 6th attack. This disregard for congressional oversight and the rule of law mirrors Miller's attempt to circumvent the Constitution and strip immigrants of their fundamental rights. The actions of Miller, Patel, and others within the Trump orbit paint a troubling picture. A group of individuals who are more interested in accumulating and maintaining power than in upholding the Constitution and serving the American people. It is imperative that the American public be aware of these threats to our democracy and hold those responsible accountable. Share this information widely, discuss it with your friends and family, and contact your elected officials. The future of our democracy may depend on it. Please like, comment, and subscribe, and watch out for the next in the Kakistocracy Continues series.